He worked illegally in Canada and lost everything in a single day. Real case, Federal Court of Canada, 2022 CF 350. Imagine this. You have your visa, you have your study permit, your passport is valid, you even successfully completed your program, and yet, in a single day, you lose everything and find yourself removed from Canada. That's exactly what happened to Anouar, and this case is real. It was pulled directly from CanLII, the official Canadian Judicial Decisions database. Reference 2022 CF 350. Today, we're going to break this case down together. The mistakes, the legal issue, the strategic analysis, and most importantly, what you need to know to never end up in this situation. Welcome to HIM Immigration. If this is your first time on this channel, welcome. At HIM Immigration, we do something nobody else does. We take real court cases, real decisions from the Federal Court of Canada, and we break them down together, like you're sitting right across from us. No theory, no generalities, concrete, real, strategic analysis you won't find anywhere else. Now, before we dive in, I'm going to give this case a score. That's something we do consistently here. I'm giving it 2 out of 10, and you'll understand why in the next few minutes. At the start, Anouar had a really solid profile, genuinely, but the mistakes he made were all avoidable. That's what makes it so frustrating. Stay until the end, because lesson number 3 is the one 90% of international students completely miss. We're going to call this the Anouar case. Anouar is a Moroccan student. He arrived in Canada in August 2018 with a valid study visa. He enrolled in a professional program that included a work placement, what's known as a co-op internship. He changed programs shortly after arriving. That's legal. He got a new study permit. Everything was fine up to that point. In February 2020, he completed his program. He had his graduation certificate in hand. He was ready for the next step, getting his post-graduation work permit, the PGWP. On paper, it's a great story. An international student who finished his studies wanting to stay and work legally in Canada. But between August 2018 and March 2020, Anouar made choices that were about to flip everything upside down. Pay close attention to this timeline. On December 18, 2019, Anouar started his co-op internship, an internship that lasted until February 15, 2020, nearly 2 months of work at a company. The problem, he had no work permit, and he knew it. The federal court stated it explicitly in its decision. He knew that a work permit was mandatory. Those are the exact words in the ruling. So on March 3, 2020, Anouar tried something, a strategy that many people in the immigration world know about. It's called the Flagpole, or in French, le tour du poteau. He left Canada, briefly stepped into the United States, and immediately came back to the Lacolle port of entry to apply for his PGWP as if he was arriving fresh. It didn't work, and today I'm going to explain exactly why. Mistake number 1, and this is the most serious. He worked without a permit, and he knew it was illegal. This isn't a matter of not knowing the law. The federal court judgment is explicit about this. Mistake number 2, he did nothing to regularize his situation after the internship. No steps taken, no voluntary disclosure, nothing. Mistake number 3, and this is where a lot of people get it wrong, the flagpole, leaving Canada and immediately coming back to file a request. Some people think it wipes the slate clean. It doesn't. It can work in very specific situations, but not when you've worked illegally just 17 days before the legal deadline. We'll break that down in a moment. Mistake number 4, he admitted everything to the border officer. What may seem honest becomes evidence against you in this context. And mistake number 5, the one rarely mentioned, Anouar failed to take responsibility for his actions in front of the minister's delegate, and that weighed heavily in the final decision. Here's the exact mechanism. It's simple once you explain it. Article 1. If you have worked in Canada without authorization,
You cannot apply for a work permit until 6 months after your last day of unauthorized work. That's what the regulation says, paragraph 203E. Anouar finished his internship on February 14th. His application was March 3rd. He was short by 5 months and 13 days. That's why the permit was refused. Point 2, and this is crucial, Anouar's inadmissibility didn't come from the fact that he had worked without authorization in the past. It came from the fact that he wanted to enter Canada to work without having the required documents. His application had just been refused, so he didn't have the right papers. The federal court is very clear on this. And point 3, the minister's delegate had full legal authority to exclude him directly without referring him to the immigration division. You see, no gray areas, no injustice. The law was applied exactly as written. The problem is that Anouar didn't know it well enough, or rather, no one had explained it to him properly. Now, here's what we would have done if Anouar had come to us for advice. Because look, this case wasn't hopeless, far from it. There were solutions. You just had to know them and apply them at the right time. Advice number 1, before the internship, get the right permit. The very first thing to do. Check whether the co-op internship was covered by a work permit exemption. In some cases, internships included in a study program can benefit from an exemption if less than 50% of the program takes place in a paid work environment. If that wasn't the case, he needed to apply for a co-op work permit before starting the internship. Cost a few $100s and a few weeks of waiting. Result avoided, removal from Canada. Advice number 2, after the internship, proactive and strategic disclosure. If Anouar had come to us after the internship, we would have recommended a proactive approach, consulting a specialized lawyer to assess the possibility of a voluntary disclosure to IRCC. In some cases, an honest declaration accompanied by mitigating factors can avoid escalation. Risky, yes, but less risky than an unprepared flagpole. Advice number 3, the 6-month rule. Wait and prepare. The regulation is clear. You must wait 6 months after the last day of unauthorized work. Last day, February 14th, 2020. Legal date to submit the application, August 14th, 2020. We would have advised Anouar to stay in Canada with his still valid status, prepare a solid application by August 14th, and submit his PGWP application online from inside Canada without crossing the border. Advice number 4. Never do a flagpole without prior analysis. The flagpole is a tool, not a magic solution. It works in very specific cases. In Anouar's case, it was the worst possible move. By crossing the border and coming back, he put himself in the position of a foreigner seeking to enter Canada to work without having the required documents. That's literally what the law says. We would have told him clearly, do not move from the border before August 14th. You see the difference? With the right information at the right time, this case would have ended very differently. Anouar would have gotten his PGWP in August 2020, started working legally, and built his permanent residence file. Instead, he has an exclusion order, a federal court decision from 2022, and probably a 1-year ban from entering Canada. An entire life turned upside down by mistakes that could have been avoided. That's why we make this channel. On March 9, 2022, the case was heard by the federal court in Montreal. On March 17, 2022, Justice Martine Saint-Louis delivered her judgment. I quote, "The decision of the minister's delegate is coherent, intelligible, and transparent, and is justified in light of the evidence on record and the clear language of the relevant legislation and regulations." Translation, Anouar loses. The application for judicial review is dismissed. The exclusion from Canada stands. 2 lawyers, 2 years of court proceedings, and in the end, the same conclusion as March 3, 2020 at the Lacolle border. Official reference for those who want to read the full judgment, 2022 CF 350. I'll put the link in the description. Lesson number 1. A co-op internship is not automatically authorized. If your study program includes a work placement, check before you start whether that placement is covered by your study permit or if it requires a separate co-op work permit. This check takes 10 minutes. Ignoring it could cost you your status in Canada. Lesson number 2, the flagpole does not erase your history. It's not a reset button. It's a legal tool that works in very specific cases. If you have any irregularity in your file, consult a professional before doing anything at the border. One wrong decision there can trigger an immediate removal order. Lesson number 3, the 6 months rule. Memorize it. If you've worked without authorization in Canada, you have a 6-month legal ban before any new work permit application. No exceptions, no flagpole that bypasses that. Wait, prepare your file, and submit on the right date. Save this video.